The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. 3 cases will be submitted this afternoon. Those cases are Caitlin Johnson versus Humboldt County and Sandra Becker. Second case is State of Iowa versus John Ness. And the final case is Iowa Supreme Court Attorney Disciplinary Board versus Sean Joseph Berry. The last 2 cases are now submitted to the court without oral argument, and we'll proceed to hear the arguments in Johnson versus Humboldt County. Mr. Meis.
May it please the court. Counsel. Plaintiff Appellant Katie Johnson asked the court to do 2 things today. First, to reverse the district court's dismissal of all counts against the county and to find that in fact the county does owe her a duty and that the public duty doctrine does not apply to the other claims beyond negligence that she has brought against the county. Second, although the first request does not require a finding of negligence, something that the jury would later decide, the second request, if the court would grant it, is to find the county negligent per se in violation of Iowa Code sections 318.4 and earlier 319.1 for its ongoing violation over 40 years of failing to remove a right-of-way obstruction from its right-of-way that then caused enhanced injuries to Katie. Although the court was not unanimous in the McFarland case, there are so many reasons in this case and on so many different levels that I'm hoping that we could obtain a unanimous verdict in at least finding that Katie was owed a duty in this case, even if there may not be unanimity in terms of the reasons why. Before I discuss the reasons why the court should rule in her favor, there are a few observations that I think will help to put things in context. First, Katie is only seeking enhanced damages caused by the county's and landowners' combined negligence, not the damages that otherwise might have occurred by reason of the simple lane departure had the county remediated the right-of-way before the date of the collision. Second, this court has never applied the public duty doctrine in a right-of-way obstruction context. Third, applying the public duty doctrine here would require the court to overrule long-standing precedent recognizing the highway authority's duty to the injured traveler. 4, affirming the dismissal would expand the public duty doctrine into new areas of law, including premises liability and nuisance. 5th, even were it not abandoned, applying the public duty doctrine under the facts of this case conflicts with the very foundational language found in Section 288 of the Second Restatement. 6th, continuing, let alone expanding the public duty doctrine conflicts with the Third Restatement and the Iowa Municipal Tort Claims Act. And 7th, the unlimited liability and parade of horrors that is predicted by the county and the municipal amici is entirely overblown. It misstates and fails to consider many of the exceptions that are applicable in many of the cases that it cites by reason of various exceptions under both of the Tort Claims Acts. Before explaining how these predictions are misguided and before explaining how the public duty doctrine is inapplicable in this case and inconsistent with the Third Restatement, I'm first going to distinguish this case from McFarland, on which the county has highly relied. A state of McFarland was a case in which the state of Iowa owned the lake bed underneath Storm Lake and was subject to the public trust doctrine. By reason of that, the state had to keep the lake open to the public. Here, in contrast, the county's right-of-way easement is not subject to the public trust doctrine. As a result, the county had the authority to close its right-of-way at any time and even to permanently vacate it if it chose to do so. On a lake, detecting and managing the dangers for the protection of boaters, swimmers, fishermen, and others can be rather complex. The wind, the current, the constantly changing water levels all combine to make what is safe one day hazardous the next. The size and draft of a boat, that's how far it extends down below the surface of the water, varies from boat to boat, so that what is dangerous for one may not be dangerous for another. And in McFarland, the depth and location of the dredge pipe constantly changed. Here, in contrast, the right-of-way obstructions are fixed, easy to identify, and visible. In fact, the rather large wall sitting in the right-of-way in this case was visible for more than 40 years. On lakes, boaters can steer far away from obstructions. On highways, it's impractical for travelers to entirely avoid the obstruction altogether because the very nature of a highway is linear. The highway guides the travelers towards the very zone of danger in which the right-of-way obstruction exists, so that it is not entirely impossible to avoid that danger. On lakes, they can steer well around, and they're also protecting dangers on a lake is difficult as a practical matter because a person can enter a lake from any part of the shoreline. It would be impractical to put a barricade around the entire lake, if not impossible. Once on the lake, a person can approach a danger from 360 degrees. In contrast, managing the right-of-way obstruction dangers in this context is not very difficult at all. It would only have taken a matter of hours for a backhoe to have removed the wall in this case and to return the ditch to the conformance with the county's right-of-way entrance policy, which is seen at the appendix page 237. Even if an obstruction cannot be immediately removed or in a timely fashion, the county had other options available to it. It could install warning signs, sleeper strips, fitch barrier systems like referenced in the brief, and in those more difficult situations, because of the linear nature of a highway, the county would have the ability to put barricades on both ends to keep the travelers out and away from the zone of danger. In this case, the statutory duty is clear. The county shall remove all right-of-way obstructions, and the purpose is express, to protect the safety of travelers. In McFarland, there was no express purpose, perhaps because there was no real duty. The plaintiff in that case attempted to put together a patchwork of regulatory sections with no clear direction or duty. It would have cost nothing for Humboldt County in this case to have remediated its right-of-way before the date of the collision. There is a cost-shifting provision in Chapter 318 that takes all of the expense of right-of-way obstruction away from the county and places it rightfully onto the landowner or other person responsible for that obstruction. In McFarland, there was no cost-shifting mechanism available. Significantly, in McFarland, the DNR lacked control. All of the day-to-day operations and the ownership of the dredge pipe and equipment, the placement of the danger buoys and so forth was all turned over to local non-state entities. Here, in contrast, the county had control. As discussed on pages 20 through 22 of Katie's reply brief, the county had control over the right-of-way by statute, by case law, by its own county ordinance, shown on beginning on page 237 of the appendix and continuing, and it even exercised that authority and control over its right-of-way as demonstrated by its right-of-way remediation activities, beginning on page 247 of the appendix. In fact, there's a picture on page 248 of the appendix of a wall very similar to the one at issue in this case that the county removed from its right-of-way by its insistence before the date of the collision in this case. The same could have been done here with no expense to the county. I don't have sufficient time to talk about all of the different ways in which the municipal amicus parade of horrors will not occur, but I do want to address a few. On pages 18 through 20 of its brief, it has a list of about, let's say, a dozen cases that supposedly would result in liability if the public duty doctrine is abandoned today. Not true. If you read the facts of those cases, you will find that in many of those cases, most of them, they would be dismissed on other grounds due to other exceptions under the tort liability statutes. For instance, Ashton, Colby, Hildenbrand, and Mastenberger, by my count, would all be dismissed under the discretionary function exception. Dooley, Allen, Sankey, Morris, all under the emergency response exception of the Municipal Tort Claims Act in section 670.4, sub 1, sub K. The licensing exception would apply to Colby. I'm sorry, that's a state case, but there's a licensing exception under the Iowa Municipal Tort Claims Act. The due care exception in Hildenbrand, and finally the exceptions for false arrest, malicious prosecution, and abuse of process in reference to Smith. So again, there are many other exceptions to liability under the tort claim statutes that would otherwise resolve what the municipal amici would like to paint as a big problem for the municipalities. By the way, both tort claims acts contain exceptions to liability for things such as roadway design, but significantly, they exclude from the exception highway maintenance, permitting highway maintenance cases and right-of-way obstruction cases like this to proceed to jury expressly. There's other things that are wrong with the municipality's brief, and I had more opportunity or space in my brief to respond to the counties, so I'm just going to pick out a few for the municipalities. They complain about becoming liable for conduct outside the municipality's control. Well, control is an important factor in the course of determining duty. So if they truly had no control, one would expect that Section 7 would not assign a duty to them, and it would become a Section 37 case under the Restatement Third to determine whether there may be some affirmative duty. They complain about becoming liable automatically in the event the public duty doctrine is abandoned today. Not true. The public duty doctrine deals only with duty, not negligence. Later on, the jury would have to determine whether, in fact, the government was negligent for its conduct. They complain about second-guessing decisions regarding how resources are spent on roads. This is particularly off-point. In both chapters 318 and 319 before, there were cost-shifting provisions, as we talked about before. There is no need to expend government resources to remove right-of-way obstructions. Moreover, there are exceptions that would apply at higher at higher levels in terms of discretionary function that would also need to be taken into consideration. Even if the public duty doctrine is not abolished, it clearly does not apply in this case. Section 288 precluded finding a duty in statutes or rules whose exclusive purpose was to secure rights to individuals to which they are entitled only as members of the public. Here, the very express purpose shows a contrary purpose so that the exclusive purpose cannot be what would be necessary for the public duty doctrine to apply even under the Restatement Second. Section 315, comment D, says that if a force is within, this is under the second restatement, if a force is within the actor's control, his failure to control is treated as though he were actively directing it and not as a breach of duty to take affirmative steps to prevent its continuance. The meaning of that is that here, because the Becker's actions constructing and maintaining the right-of-way obstruction were within the county's control, under the Restatement Second even, on which the public duty doctrine in part relied, Section 315 treats the county's failure to control as though the county itself were actually actively directing the Beckers to obstruct the right-of-way. In conclusion, it's worth considering how the county and municipal amici have failed to address some key questions. First, if the third restatement did not step away from or abandon the public duty doctrine, then why is the foundational language in Section 288 of the second restatement not carried forward in any sectional language within the third restatement? Second, aside from speculative concerns about unlimited liability, for which they offer no evidence, which is the prerogative of the legislature, as this court so skillfully articulated in the Wilson case, what good public policy is advanced by applying the public duty doctrine in this case? Third, mindful of the separation of powers and institutional comity, Does the court better fulfill its constitutional role by accepting the legislature's express policy of right-of-way safety for travelers and municipal accountability, or by stepping in to protect negligent municipalities from a responsibility through the use of judicial doctrines designed to second-guess the wisdom of those legislative policies? This is significant. Applying the public duty doctrine here would swallow the entire exception in section 318.4, converting the legislator's mandatory delegation of a duty into a mere aspirational resolution. The county owed Katie a duty for various reasons, paving the way for what I hope is a unanimous decision in her favor. One of the great things about America is how the weakest in society is able to go into a court of law and hold accountable the most powerful of interests, even the government, when the government has caused harm to one of those people. Abandoning the public duty doctrine will help to ensure that Katie and others similarly situated will still have that door to justice open to them. It's also consistent with the legislative policies of right-of-way safety and municipal accountability, and as a matter of institutional comedy, will prevent the awkward situation of this court condoning that conduct which the legislature, as the authoritative source of community conduct, has made unlawful. Thank you.
Mr. Meis, thank you as well. Mr. Lapierre?
May it please the court, opposing counsel. Good afternoon. My name is René Lapierre, and I'm here on behalf of Humboldt County, who was one of the defendants in the litigation and the only appellee as a result of the county's motion for summary judgment, which was sustained by Judge Stovey. But this case clearly has implications not only for Humboldt County, but all 99 counties in Iowa, along with municipalities in the state, with the miles and miles of roadway. I'm going to apologize to the court. I am adjusting to hearing aids, so my voice may fluctuate quite a bit because I'm not sure if I can hear myself, and if I do, I'm really not sure what I'm saying. So if you hear me yelling at times, it's because my hearing aids are not functioning very well. Again, my apologies, but I'm adjusting. First of all, I think it's a good opportunity to review the bare facts in this case, because the facts dictate the result. It's a single vehicle accident at 2:30 in the morning in Humboldt County, Highway C-49, a rural road. The vehicle leaves the roadway, crosses another lane of travel, and enters the ditch. It travels almost a football field, around 80 yards or 242 feet in the ditch, at the same speed, 60 miles an hour. There is no reduction in speed. Shortly before impact, the speed goes down to 58 miles per hour. What the vehicle hits is a concrete embankment that was essentially constructed for agricultural purposes by the Beckers some 40-plus years earlier. It was part of a cattle operation. It was help cattle stay in. This particular concrete embankment and cattle guard was partly in the right-of-way and partly on the Becker's property. When it was constructed in 1972 or 3, there were no permit requirements or anything along those lines.
But doesn't, under 318.4, the county has a duty, I mean, I'm just reading it, the highway department shall cause all obstructions in the right-of-way to be removed. Doesn't that create an affirmative duty?
The duty created in 318.4 is nothing less than the duty this court considered in the McFarland when the word duty was repeatedly used in those statutes.
But here we have an express statute that commands the county to do a specific thing, namely remove an obstruction, and the purpose of the statute, 318.4, is to promote public safety. Hasn't the legislature taken this outside the scope of a public duty doctrine by its express legislative action here?
I don't believe so, Your Honor. I think when you look at the Municipal Tort Claims Act and you look at the Iowa State Claims Act, Tort Claims Act, I think what's apparent is both of those have been ruled by this court, the public duty has still applied despite the enactment. And if, in fact, the legislature wanted to abandon or abrogate the public duty doctrine, which is clear by this court to be the law, then to right across the street, they can enact a provision that says the public duty doctrine is abrogated.
Well,
But didn't, by enactment of the State Tort Claim Act, and over the years, they've amended it to take out, they added state-of-the-art and all those other things, but they left in it, it doesn't affect the duty to maintain. I mean, so if we adopt your maybe this question is the right question. If we adopt your public duty doctrine, tell me when a city would ever be liable for failure to maintain a highway, or failure to sign, or a county, for proper signing, failure to remove snow. Tell me when they'd ever be liable, because those are all duties that generally go to the public.
I think what's going to happen is, first of all, factually, the county had nothing to do with the design, construction, or maintenance of this particular embankment cattle guard. There's no notice to the county that there's any issue with it.
That's a different answer. The question is, tell me a situation when a county would ever be liable because the statutes say they have to maintain the highways. There's other statutes besides the one involved in this state. The statutes say they have to provide adequate signing. Tell me when they would ever be liable under your broad interpretation of the public duty doctrine.
Well, what I would see then is there is notice to the county of a hazard. The hazard exists. It exists for a period of time, and then the county did nothing.
I think, I'm not buying that, but I think maybe potentially, you would agree there would be a difference, first of all, if the county had erected the embankment, because the public duty doctrine is only a doctrine of municipal or government inaction. It doesn't protect the government where it acts and then acts negligently, correct?
Absolutely.
That would be one. Secondly, it's my understanding, correct me if I'm wrong, this area of the property, the ditch, it's an easement of the county. It's a right-of-way easement. Is that right? Or does the county actually own the ditch, or does it just have an easement?
Easement right away.
Okay, so the embankment is actually on private property to which the county has an easement. Is that correct?
That's correct.
And so maybe we'd be talking about something different if we were talking about an obstruction that's in property that's actually owned by the county, even if the county didn't put it there.
I think we'd be talking about different things. But basically, as we look both at section or chapter 318, because we keep talking about a statute and what it created, a private remedy, a private cause of action or a private remedy, and when you look back at chapter 657, basically under 318.6, any person who places or caused to be placed an obstruction in a highway. It wasn't the county that placed it or caused it to be placed there. And similarly, when you look at the chapter on 657 on nuisance, whatever is injurious to the health, indecent, or reasonably offensive to the senses, again, that's section 657.1. So there's no private cause of action either created or any remedy that I can find in section 318.2, or pardon me, chapter 318. And we keep talking about the traveling public. Well, that is it. It's a public duty. I mean, really, here is not the county supposed to be the police officer or park ranger has been.
But it's not a police officer situation. Let me share with you, and I know you're familiar with section 38 of Restatement Third, but I'm going to read part of it to you and then read part of the statute as well. But section 38 talks about actually special duties, I think. But when a statute requires an actor to act for the protection of another, the court may rely on the statute to decide that an affirmative duty exists. And then the statute says the highway department shall cause all obstructions in the right-of-way to be removed. And 318.2 says the purpose of this is for the safety of the public. So under section 38, when a statute requires an actor to act, 18.4, the highway department shall cause obstructions to be removed, and it's for the benefit of safety. Don't they survive summary judgment on the duty issue?
I don't believe so, Your Honor. I believe we come back to just like the district court did, no matter what theory you call it, it's under the public duty doctrine that, as near as I can tell, has survived for years.
I think there are aspects of the public duty doctrine that may well survive. It's a narrow doctrine. It usually applies in three contexts: police and fire, escapees, and licensure, and maybe a few others. But if you look at all the case law, it's mostly police and fire and licensure. And the notion there is that the duty has not been clearly established by any particular legislative enactment that's really primarily involved, et cetera, et cetera. And I'm sure you've read the cases too. But here, the legislature's been very, very direct. And although it may be that the obstruction was created by a third party, and it may be that the obstruction is on land that the county only has an easement to, the statute imposes a duty of removal. It's expected that government comply with that duty, and it takes it outside the public duty doctrine.
And I don't believe so, Your Honor. I think the statutes, when you're talking about what a remedy is, nothing in 318, nothing in the public nuisance doctrine says that as a result of this duty that there's a private cause of action or a private remedy. I mean, when you compare 318, 657, whatever statute we want to compare them to what this court did in McFarland. Those statutes went much further than a blanket statement about duty. Much, much further. This talks about duty, and then it starts talking about remedies. But what is it for? It's for the public in general, the traveling public. Well, according to this court, they haven't been overturned. The public duty, well, Harriman was different because factually different. I mean, it really took on it owned, directed, it did all of those things. Here, that didn't happen.
But the statute gives them authority to direct that the obstruction be removed.
It does, Your Honor. It does give them that authority to remove it. But isn't that back to what we were talking about? Isn't that really similar to a police function or a park ranger function? They're policing the safety issue, just like police officers, just like park rangers. That's what this court has used for an analogy. So what are we doing here for these obstructions? I mean, in light of this decision, what are 99 counties in Iowa supposed to do? Go check every roadway for every field access that's in a right-of-way and an easement right-of-way, whatever it might be, and if it's built up, is that going to have to go?
I think your argument goes to the legislature. They said the highway department shall cause all obstructions of the right-of-way to be removed, and it's for public safety. If you don't like that directive, you got to go to the folks across the way and say something.
Well, if the folks across the way wanted to abrogate the public duty doctrine, I think they would have said that to the court. Even McFarland. McFarland was issued in 2016. Nobody in this courtroom is aware of any legislation to suggest the public duty doctrine is done.
Counsel, in my dissent in McFarland, I listed the jurisdictions that had abandoned the public duty doctrine, most of them rejecting it on the basis that it was sort of an anachronism given the abandonment of sovereign immunity. And I'm just curious, did you check to see if any additional jurisdictions have gone in that direction since middle of 2016?
I did not, Your Honor. I mean, and also in your dissent, though, you also talked about the factual pattern and understanding the factual pattern. That's the factual pattern that we have before us, but its implications not only to Humboldt County, but every county in this state. And when it comes to the public duty doctrine, I mean, we keep going back to the traveling public, and that's where the duty is owed, the general public, not this specific individual's claim that there was a duty. There has been a constant discussion about sovereign immunity and the public duty doctrine. I think analytically, I think you pointed out very clearly in your dissent that analytically there's a difference. But also, if this court decides to abrogate the public duty doctrine or it doesn't apply in this case. What I am very confident of is we're going to be back up here talking about the Iowa Municipal Tort Claims Act and whether there's an exception for this very thing. So that's why I believe that the public duty doctrine is squarely before the court again. It applies in this case. And if not, then I'm confident we'll be back here arguing about the exceptions to the Iowa Municipal Tort Claims Act.
Counsel,
Thank you. Oh, I'm
Counsel,
sorry.
before you sit down, you know, as you know, in my dissent in McFarland, I talked about Section 7 and the notion under the restatement third that if you have a no-duty rule, it should be based upon a clearly articulated policy consideration, a strong policy consideration supporting it. Would you just try as best you can concisely to state what you advance as that strong policy consideration?
Agricultural purposes. That's what it's about. Thank you.
Mr. Lapierre, thank you as well. Rebuttal, Mr. Meis?
May it please the court. Lane departure is expected, and there is plenty of material in the brief and the appendix that talks about how the government has known about lane departure for a long period of time. So it's not surprising that sooner or later somebody was going to hit the obstruction in this case. There was some talk about the facts in this case, but really the only meaningful facts in this case is whether is what enhanced damages were caused by the right-of-way obstruction that was still there. Again, this is not a case where Katie is seeking damages for the minor soft tissue injuries that Dr. Croft found would have occurred had there been a lane departure after the county had remediated. We are only seeking the enhanced damages caused by reason of the county's failure to see that the right-of-way obstruction was sooner removed. And so the reason for lane departure is entirely irrelevant. Comparative fault with the driver really isn't even at issue. The only real comparative fault is between the landowner and the county. And there's talk about enhanced damages in the comments in relation to Section 40 of the third restatement that I think are on point. Talking about facts, the cattleways at issue in this case was not even serving any purpose. That's admitted, and that's also in the record. The landowner admitted that it served no useful purpose as of the date of the collision. So agricultural purposes doesn't even explain that.
I think you probably want a question at some point, Mr. Meis, so let me give you one. There are different articulations for why there is a public duty rule. The one that kind of appeals to me, because I joined the McFarland majority, is this, and it is that the legislature tells governments to do all kinds of things. It tells them to make sure Storm Lake is safe and properly managed. It tells them to make sure there are no obstructions in the right-of-way. The federal government says there should be no folks in this country that don't have a legal right to be here, but we have many people who are in this country that came here and are here today. So the government, the legislature hands out dictates, but they don't give up enough money, and this is the very problem we experience in this branch of government. And the public duty doctrine says that where government, it's a government failure to act, not a government affirmative action, but when it's a government failure to act, and the failure to act is on a duty that's owed to the public generally, we don't impose tort liability. And what's wrong with that rule?
I believe you'll find that the case law before the Tort Claims Acts was even more harsh or stringent in relation to government accountability when it came to omission as compared to performing a function. The Tort Claims Act then said that it doesn't matter whether it's omission or conduct. So here it doesn't really matter. I think really your question, and I thank you for the question, I think it gets really to the heart of the Tort Claims Acts themselves. Was the legislature wise in passing the Tort Claims Acts in the first place? And I think as to the second part of your question, is the public duty doctrine really so bad in light of what you just described? I think the more important point is it's outlived any useful purpose it had, and it's inconsistent with the third restatement. When the Iowa court first adopted the public duty doctrine back in 1971 in the Jahnke case, it was in response to mob violence that the police department was responding. There was an emergency. And so what did the legislature do in 1974 but amend the Iowa Tort Claims Act to now provide discretionary function as an exception to liability? So that situation is taken care of. Also within the Iowa Municipal Tort Claims Act, and I believe the other one, is an emergency response exception. If you're responding to an emergency, and it gives an example, but it's not an exclusive example, if you're responding to an emergency, that's accepted from liability under the Tort Claim Act. And then the third...
Mr. Meis, let me quick ask you a question.
Yes.
Is it essential to your claim that this was a man-made obstruction?
No, it is not. Particularly if you look under the premises liability angle that we have brought, there is a duty under the restatement to check and see if you have problems with the defects on your property. And in this case, we're not talking about one that could not be easily detected. It was clearly visible for more than 40 years. So it does not matter the reason why the obstruction came about. The statute's clear, you have to remove it, and so under the common law in terms of maintaining your highway. As far as the county having notice, with more than 40 years gone by, the county had more than enough notice. It knew it was there. It resurfaced the road 3 times, feet away from the very, and think of all the other things the county would have done in terms of taking care of, clearing off the snow, putting salt on, highway patrolmen going back and forth. There's multiple county officers and personnel that would have gone by that site multiple times, probably a week, if not at least a month, throughout more than 40 years. So there's clearly notice here.
You may sum up.
Thank you. In this case, the public duty, I can see, one thing that's always bothered me about McFarland is that it makes an analogy to travelers on the highway. And if you go to the restatement second, where that's the foundational language for the public duty doctrine, comment C talks about, as an example, a statute that's designed to provide unrestricted passage to travelers. So you get the idea that, oh, well, there you go. Maybe a case like this would be subject to the public duty doctrine. But if you read on, it explains that if a traveler is injured, they then have standing different from the rest of the community. It's a lot like a nuisance, public nuisance claim. You don't have standing to sue until, in fact, you have been injured, and then you gain that standing. And then it goes on to say, in ordinary cases, the harm suffered by the individual is not within the purpose of the statute, whereas right here it clearly is. So for all of these and other reasons, I thank you for your time, and I ask you to do one other thing, and that is to, in response to the concern about confusion in the law and unnecessary litigation, I think this court could really simplify things for everyone if it would really jump in with both feet on the restatement third. We have a lot of guidance, not only for practitioners in guiding our clients, but also for the municipalities, so they know what's accepted and what's not. And the public duty doctrine is clearly inconsistent with the third restatement. Thank you.
Mr. Meis, thank you, and Mr. Lapierre, thank you as well. The case of Johnson versus Humboldt County is now then submitted, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.